Why do most legal disputes never make it to trial? Because skilled lawyers know how to negotiate persuasively, strategically, and in their client's best interest. In this lesson, we're going behind the scenes of high stakes settlement talks. You'll learn the vocabulary of negotiation, words like settlement, leverage, impasse, and terms. You'll also master persuasive language structures and conditionals used to present offers, make predictions, and push through legal deadlocks. This lesson is part of our full legal English course for lawyers and professionals. If you want all the lessons, live coaching, and a supportive community, join us in school. The link is in the description. Today's lesson will sharpen your negotiation skills, especially for settlement discussions. We'll focus on high-level vocabulary like settlement, leverage, impasse, and terms. You'll also develop your command of persuasive legal grammar, using conditionals to describe possible outcomes like, if we accept the terms, we'll avoid trial. Using modal verbs and rhetorical framing to make strong, confident proposals. By the end, you'll be able to lead a strategic legal discussion with clarity, confidence, and control. Let's warm up by reflecting on real negotiation dynamics. What comes to mind when you hear settlement negotiation? Maybe you picture lawyers around a table debating damages or final terms. Maybe you think about avoiding trial, protecting your client's reputation, or drafting clauses that both sides can live with. In legal practice, settlement is often more than a financial decision. It's strategic, emotional, and time-sensitive. Consider these common elements: legal risk and how much pressure each side feels, client expectations and consent, confidentiality, and what terms are non-negotiable. Now, try completing these thoughts with real-world insight. One reason a client might prefer settlement is to avoid the uncertainty and cost of a prolonged trial, especially when the outcome is difficult to predict or the dispute could harm their reputation. If the parties reach an impasse, it may be necessary to bring in a neutral mediator, reframe the offer, or escalate the issue to court, depending on how much leverage each side holds. The terms of a good agreement should reflect a realistic compromise that protects your client's core interests, minimizes future liability, and is clear enough to prevent future disputes. We'll build on your reflections as we explore vocabulary, grammar, and negotiation strategy in depth. A settlement is the legal equivalent of a handshake, but with carefully drafted terms behind it. It means both sides have agreed to resolve the dispute without going to trial. Take this example. The parties reached a confidential settlement after weeks of negotiation. This tells us they avoided litigation by coming to terms behind closed doors. In practice, settlement may include financial compensation, confidentiality clauses, or structured timelines. For many clients, a smart settlement is about control. It avoids the unpredictability of court while saving time and money. In legal negotiations, leverage is power, the kind that shapes outcomes without ever stepping into court. For example, the threat of bad publicity gave the claimant significant leverage. Here, the claimant didn't need to win in court. The potential damage to reputation was enough to push the party towards settlement. Leverage comes in many forms: strong evidence, a favorable jurisdiction, or even media attention. The key is knowing how and when to use it without overplaying your hand. Impasse. An impasse is the negotiation equivalent of a red light. Nothing moves forward. For example, talks reached an impasse when neither party would compromise. This happens when both sides dig in, refusing to adjust demands or expectations. Experienced lawyers don't panic at an impasse. They reframe offers, introduce new value, or suggest mediation. Sometimes walking away is strategy, but often an impasse signals a need for creativity or fresh perspective. Concession. A concession is the art of giving something up strategically. For instance, the employer made a major concession on severance terms. That doesn't mean weakness. In fact, smart concessions can unlock agreement. A skilled negotiator knows when to concede and how to trade that for something more valuable in return. It's a game of balance. Protect your client's core interests while showing flexibility. Binding. Binding is what separates talk from obligation. The agreement became binding once both parties signed. That means each side can now be held accountable, in court if necessary. In negotiation, the shift from proposal to binding agreement is critical. Lawyers must ensure every clause reflects their client's intent and that no one walks away with unclear obligations. Once it's binding, there's no turning back. Without prejudice is one of the most powerful shields in negotiation language. When you say the offer was made without prejudice, you're protecting your client, ensuring that negotiation efforts can't be used against them later. It's a safety net. You can explore options, propose terms, or even apologize without risking that information being introduced in trial. But beware, misusing the phrase doesn't guarantee protection. The context, jurisdiction, and actual content matter too. Let's do a word bank challenge now. You are advising a small startup being sued by a multinational competitor for breach of contract. On paper, it looks like a tough fight, unequal resources, high exposure, but then you uncover a detail in the original emails. The other side made a promise that contradicts their legal position. Suddenly, the power shifts. Your client can threaten to expose this inconsistency in open court, and the reputational damage could cost the other party more than the dispute itself. Now, instead of defending, you're negotiating from a position of strength. So, what's the term for a strategic advantage used to influence negotiation outcomes? That's called leverage. And in high stakes settlements, it's often more powerful than the law itself. Let's go ahead to another one. Two companies have been negotiating for weeks. They've gone back and forth on price, delivery, dates, and liability. Finally, one side refuses to budge on indemnity. The other side won't move on payment terms. They've both reached their limits. There are no new proposals on the table, no flexibility left. Tension builds, and the tone in emails shifts from collaborative to confrontational. At this point, no matter how skilled the negotiators are, there's no forward motion. What do we call it when negotiations break down and no agreement can be reached? That's an impasse, and breaking it often requires creativity, compromise, or the threat of litigation. On to another one. A real estate developer is negotiating with a community group over zoning rights. The developer wants full commercial use. The group demands green space and traffic limits. Finally, the developer agrees to reduce the size of the project and include a public park. Not because they want to, but because it's the only way forward. They've given up something to secure the bigger win, the permit to build. What's the term for something a party gives up during negotiation to reach agreement? That's called a concession, and skilled negotiators know when to offer one and when to hold firm. Now let's imagine a wrongful termination case is headed for court. The employer denies everything. The employee has strong evidence, but the stress, publicity, and costs weigh heavily on both sides. Then, through mediation, the employer agrees to pay a fair severance package, and provide a neutral reference. The employee agrees to drop the claim. Neither party wins, but both avoid the risk and cost of litigation. What's the legal term for an agreement that resolves a dispute without going to trial? That's a settlement, often the most practical and strategic solution in contentious legal matters. After 3 months of back and forth, two corporations finalize a deal to settle a patent infringement case. The agreement outlines payments, deadlines, and confidentiality terms. Both CEOs sign, there's no turning back. If either side violates the deal, they can be taken back to court. What's the word for a legal agreement that must be followed by both sides? That's binding, the moment when a negotiation turns into an enforceable obligation. On to the next one. A lawyer emails opposing counsel with a proposal. We are prepared to settle for $150,000 if this can be resolved this month. A few days later, talks collapse and the case proceeds to trial. The other side tries to use that offer as evidence of guilt, but they can't, because at the top of that email were two powerful words that keep negotiations separate from litigation. What phrase protects negotiation statements from being used later in court? That phrase is without prejudice, a shield that keeps candid offers out of the courtroom. In legal negotiations, conditionals are more than grammar. They are strategy, and each type expresses a different kind of possibility or consequence. That's why you see this grammar over and over in our classes. The first conditional talks about real possibilities in the future. If we accept the offer, we'll avoid trial. This is a tool for clear advice. What will happen if the client takes action now? The second conditional imagines a hypothetical or unlikely situation. If they offered more, we would recommend settlement. This lets you explore what could happen, even if it hasn't yet. The third conditional looks back at something that didn't happen, often used to analyze mistakes or lost opportunities. If they had responded sooner, we could have reached agreement. Finally, unless is a strong and polite way to set boundaries. Unless they revise the terms, we won't proceed. It's especially effective in writing, formal but firm. Conditionals give you flexibility and authority. They let you advise with confidence while keeping options open. Exactly what's needed in high-stakes negotiation. Let's step into a client meeting. Your client is anxious, unsure whether to settle or move forward. This is your chance to clarify the legal consequences with confidence. You'll need to use different conditional structures depending on the timing and certainty. First conditional for likely futures. If we reject the offer, we'll need to prepare for trial. Second conditional for hypotheticals. If they offered more, we would consider it. Third conditionals for regrets or missed chances. If we had accepted earlier, we could have avoided this delay. Now it's your turn. Choose one of the client's questions and respond using a conditional sentence. This will help prepare you to explain legal outcomes clearly and help clients make informed decisions under pressure. Moving on to modal verbs. Modal verbs are one of your most important tools when speaking with clients. Each one allows you to give advice or frame a decision without sounding too forceful or too vague. Use should to give strong but respectful guidance. You should respond before the deadline to show good faith. Use might when there's a real risk but not a certainty. They might withdraw the offer if we wait too long. Use could when presenting a possible benefit. This clause could protect your IP rights long term. Use must when the issue is non-negotiable, legal, procedural, or tactical. You must appear at mediation or risk default judgment. A persuasive lawyer knows when to soften, when to press, and how to keep the client informed without overwhelming them. These verbs give you just the right degree of control. Beyond verbs, persuasive legal language relies on framing, the way you present a situation to influence how it's understood. Notice the difference between emotion-driven language and strategic professional framing. Instead of, "This offer is low," say, "This offer reflects their current position, but there's room to move." This keeps the conversation open and shows leadership. Instead of saying, "We're running out of time," you say, "We have a window to finalize this, but it's closing quickly." This implies urgency without panic. Instead of saying, "They're refusing to negotiate," say, "They've drawn a line, but we can propose alternatives." This shows you're still thinking creatively and protecting your client's options. Rhetorical framing helps you de-escalate tension, maintain professionalism, and keep the negotiation productive, even under pressure. Let's walk through how you might guide this conversation in a real legal consultation. We should consider the long-term cost, because a drawn-out trial could easily double your legal fees and drain your time and energy. The court might view this as a reasonable offer, and if we reject it, we risk appearing uncooperative. This offer could allow you to avoid public exposure and preserve your business reputation, which is hard to recover after litigation. You must respond within 48 hours, or the offer may be withdrawn, and we'll lose any leverage we have. While the offer isn't perfect, it shows the other party is willing to move, and we can push for stronger language on liability. There's still room to negotiate, but the window is closing, and silence could send the wrong message. When you speak this way, you're not just informing the client, you're positioning them to make a clear, confident, and legally sound decision. Meet halfway. Imagine a mediation session between a landlord and a tenant. The landlord wants full back rent, while the tenant can only afford partial payment after losing work during a crisis. The mediator listens carefully, then helps both sides refocus. The landlord agrees to waive late fees. The tenant offers to pay in installments. They've met halfway, not because either side got everything, but because both made concessions to reach a workable deal. In legal negotiations, meeting halfway can preserve relationships and reduce the risk of costly litigation. During a wrongful termination case, the employer offers a small payout and a vague reference. The employee's attorney pushes back, citing reputational harm, loss of income, and procedural irregularities. After several tense sessions, the lawyer secures triple the original offer and a neutral reference letter. That's driving a hard bargain, using facts, legal leverage, and confidence to shift the negotiation in your client's favor. In mediation, driving a hard bargain means standing firm, but still aiming for resolution. Throw someone under the bus. In a commercial dispute, a company is accused of violating environmental regulations. During settlement talks, the corporate counsel shifts blame onto a former junior manager, claiming they acted without authorization. Internally, it's seen as damage control, but ethically and perhaps legally, it's questionable. This is a classic example of someone being thrown under the bus, sacrificed to protect a larger interest. Negotiators must walk a fine line between defending their client and preserving integrity. Reputation and fairness matter too. Break the deadlock. In a construction defect case, both parties blame each other. The developer won't admit fault, and the supplier refuses to pay damages. After 2 days of failed talks, the mediator suggests an alternative: a third-party audit and a shared remediation fund. Surprisingly, both sides agree, not because they fully trust each other, but because it creates a path forward. That moment broke the deadlock, a creative, face-saving solution that allowed everyone to move on. Sometimes breaking the deadlock requires more than legal arguments. It requires empathy and innovation. Let's finish with a story. It was a high-stakes mediation between an international software firm and a former executive who had filed a breach of contract claim. The case had stalled, both sides entrenched, and the mediator worried they'd reached an impasse. The executive's lawyer had leverage. Emails suggesting promises were made about bonuses and exit terms. But the company's counsel was prepared to drive a hard bargain, offering a narrow severance with strict non-disclosure terms. At one point, the company threw its HR director under the bus, suggesting she acted independently, a risky move that nearly derailed the talks. The mediator refocused the room. He used conditional framing to guide the conversation. If this goes to trial, you might both lose control of the outcome. We could explore a creative solution that preserves face on both sides. You should consider the reputational cost of continued litigation. Eventually, the executive agreed to a reduced payout. The company agreed to revise language in the press release. Each side made a concession. They met halfway. And with that, the mediator helped break the deadlock. It wasn't a perfect deal, but it was a smart, strategic resolution. And the language used around that table made all the difference. So let's review what you've learned today in our lesson on leading a legal settlement negotiation. First, we expanded your legal English vocabulary, giving you precise, advanced terms like leverage, concession, and impasse to describe critical moments in negotiation. Second, we practiced powerful grammar using conditional structures to outline consequences and modal verbs like should, might, and must to give persuasive legal advice. You also learned how to use rhetorical framing to maintain professionalism even under pressure. Third, you applied those tools in real-world scenarios, advising clients, guiding strategy calls, and managing difficult decisions with clarity. And finally, we brought in idioms that lawyers actually use, like meet halfway or throw someone under the bus, to make your communication sound more fluent, natural, and strategic. Want to keep learning? Join our school community for full course access, legal role plays, live classes, and expert feedback. The link is in the description. We'll see you inside.